Now let's talk about financing. So line 59, this is newer. It was added, I don't know, a few years ago. This is the buyer's representation that they have the liquid funds available for either the cash purchase if they're making a cash purchase or for the down payment if they're financing, and that it is not, those funds are liquid and available and not coming from any contingent source. So this is where if the buyer's money is in an IRA or some other place that isn't liquid, that they couldn't go down right now and get that money, that you disclose it. It doesn't create a contingency, it's just a disclosure. And when you're communicating as a buyer's agent with your buyer, make sure that you're specific in what you're asking them. So for example, if I were your buyer and I were buying a $400,000 home and putting $100,000 down, and I had $150,000 in my 401k, and that's where my down payment was coming from, and you said to me, so Wendy, do you have all the money that you need for this down payment? What am I going to say? Yes, I have it. It's my money. It's my 401k. But if you asked me differently and said, Wendy, do you have the ability to go down to your bank right now and bring me a cashier's check for that $100,000 down payment? Then I would have to tell you, well, no, it takes 3 weeks to get it out of my 401k. Okay, you don't have liquid funds. I'm going to write that in here at line 59 and disclose that it's coming from a 401k or coming from the sale of the buyer's property or wherever that money is, that it's not liquid at the time of the offer. Then the first option for financing is cash. Section A, line 61. What is cash? Well, you'll occasionally hear some argument, but if the buyer is going to have the cash to give the seller cash from their own accounts at closing, then I think it's cash, even if the buyer doesn't have the cash yet. So for example, if they have property to sell, I think it's fine to still mark cash, and then at line 59 you would disclose that the cash is coming from the sale and closing of the buyer's property. So you get that disclosure in there. But cash is cash if I'm going to have cash by the time we're closing. Let's talk about loans and loan types. So this is section B, if it's not cash, line 71. Make sure that you identify the type of loan that the buyer is getting, whether it's conventional FHA, federal VA. Make sure that if it's federal VA that you're marking whether or not the seller is agreeing to pay the buyer's non-allowable VA fees. If you're not clear what that is, talk to your lender. And then other would be any other type of loan, an Oregon Veterans Association loan, a USDA loan, anything that is not one of the types listed here. I want to point out that there is a difference between the cash and the loan section regarding verification. So under cash at line 62, there are some options for the buyer providing verification of funds, that they have the money to pay cash. And then notice at line 65 that after the buyer provides that verification, the seller has the right to approve or disapprove of it. It is a reasonable man standard, which is a type of contingency that doesn't allow for sole discretion. If a reasonable man would accept the verification, then the seller needs to accept it. But they have the right to not accept it. If that letter from some banker looks fishy, they can say, no, I'm not comfortable with that. Bring me a different type of verification. However, down under section B, at line 76 regarding the buyer's pre-approval letter, if the buyer does not submit the pre-approval letter at the time of the offer and says they will provide it within X number of days after acceptance, the seller does not have the right to disapprove of that pre-approval letter after they receive it. I think that is incredibly important, guys. In today's day and age, there's almost never a time when you can't get a pre-approval letter to accompany your offer. So as soon as I get an offer that doesn't have a pre-approval letter attached to it, I'm immediately suspicious. Is there something wrong with the buyer's ability to qualify, or are they getting a loan from a disreputable lender? Because if I accept this offer and say, sure, I'll take your pre-approval letter in 2 days, and then it comes in from e-loans, Quicken Loans, or some even local lender that I've had terrible experiences with, I don't have the opportunity later to say, no, never mind, I don't want you to use that lender. So understand that the seller can disapprove of evidence of cash, but they can't disapprove of a lender if they find out about it later. So I would always be asking that question if you get an offer that doesn't include a pre-approval letter. Now the financing contingency itself is all pre-printed here in the form. So it's right on lines 79 through 83. And it is very specific in saying that the buyer and the property have to qualify for the loan, and the property has to appraise for at least the purchase price. And the reason it also says the property has to qualify for the loan is because the appraiser can say, we aren't willing to loan on this property unless the foundation gets fixed or unless the heating system gets fixed. And that would mean the property doesn't qualify for the loan, and that would give the buyer an out if the seller refused to fix that. So the financing contingency lives right here in the form. If you ever have questions about it, you can read it right here under section 5.1. Then let's talk about sellers' credits toward closing costs. I see this written incorrectly more than you can possibly imagine. And it is very important that it's written correctly. I'm seeing more and more buyer's agents write a contingency for closing costs that doesn't have a figure included in it. Well, certain loan types and certain lenders will only allow a maximum amount of credit from the seller. So just saying that the seller is going to pay all of the buyer's closing costs is inaccurate. And if we actually have a seller's agent who overlooks that and lets their seller sign an offer with an unknown amount, it creates huge risk and liability on the parts of the realtors. We don't want to have that happen. So write your contingency clearly. Make sure there's an amount included. Be sure to include prepaids, because if we say the seller's going to contribute $5,000 towards the buyer's closing costs and the buyer only has $4,000 in closing costs, that other $1,000 could be used for their insurance, prepayment deposit, and their prepaid taxes, etc. So they can use the whole credit. Buyer's agents, please make sure you mention to seller's agents that it's there. I have had sellers agents overlook the fact that there was a credit towards closing costs, not explain it to their client or disclose it to their client, and then guess what? Their commission goes away at closing. And preferably put it into section 8. We even reference it now in the form that is something that should go into that blank in section 8 at line 138. Now let's talk about buyer representations. As a buyer's agent, you should know what these items are. In fact, let's back up for a second and talk about the sale agreement and when your clients should see the sale agreement. If you are showing a buyer property, you should be giving them a copy of the sale agreement that they will eventually sign when they're ready to make an offer. They should have the time, the opportunity to read through that sale agreement when they're not under pressure, when they haven't found a home and they don't have the adrenaline excitement of, oh my gosh, this is the home I really want, what do I need to do to get it? Have them read it and highlight the things they don't understand. And the same with sellers. You should be giving your seller a copy of the sale agreement at the time you take the listing. Give the seller an opportunity to read through, read what representations they'll be making to a buyer, and also have a chance to read what the different contingencies are and how they all work when they're not under pressure to accept an offer. So these buyer representations, your buyers should have read through these before we get to the time where they're making an offer, and you should know what they are too. So the first one is they agree to submit all documentation for loan applications to the same lender who provided the pre-approval. So they don't have the option to provide a pre-approval lender from one lender and then make loan application with a different lender. Item number 2 defines what a complete loan application is. Item number 3 is a CFPB requirement. As a result of Dodd-Frank, they have to notify their lender of the intent to proceed with their loan. And if the seller asks for evidence that they've done that, they have to provide it. So in an effort to protect the consumer, the government in their wisdom said that after a buyer makes loan application, within 10 days, they have to confirm that they still want to proceed, or the lender has to close the file. So, now lenders have gotten familiar with this, and they each have their own form that they require the buyer to sign saying yes, directing them to continue with the loan. Number 4 requires the buyer to complete their paperwork in a timely manner and use their best efforts to obtain the loan, which is a legal definition. Number 5 requires the seller's written consent for the buyer to change lenders or loan programs. I can't tell you how many buyer's agents don't realize this is in there, and how many seller's agents don't. Guys, you can't say you're getting your loan through Umpqua Bank and then decide to go to Quicken Loans later, unless the seller approves it in writing. Number 6, they have to keep the seller informed of all material loan developments, especially if closing will be affected. So it used to be that we didn't have to tell the seller anything, even if we found out that, closing's probably going to be delayed. In most cases, the buyer or buyer's agent would drag their feet until shortly before closing and then ask for an extension, because of course the seller feels compelled to provide it if closing is 3 days away and now we need another week or something like that. Now this form says if you find out there's a challenge early on in the transaction, you need to disclose it then. Number 7, request the ordering of the appraisal by the end of the home inspection period. So make sure that most lenders are doing it immediately now, but just in case, confirm with your lender that they're actually ordering the appraisal timely. And number 8, the seller's agent can obtain non-confidential information from the lender. So if you come up against one of those seller's agents who's having to come apart because you called or one of those buyer's agents who's having to come apart because you as the seller's agent called the lender, you can point to this section, item 8, and say, it says right here I have the right to do that, and the lender can disclose to me anything that is not confidential. Let's talk for just a second about insurance. Section 6.1 talks about insurance, but it is not a contingency. It's just a recommendation that the buyer go investigate insurance. But if it turns out the insurance premium on the property is going to be much higher than the buyer realized it was going to be, this doesn't create a contingency for them to terminate the transaction. So you want to make sure that your buyer has other contingencies still available to them when and if they find out that there is an insurance problem. So try to get your buyer making that inquiry early on so that you don't end up with that being a surprise problem. We are also not experts regarding flood insurance, so we never want to speak to that. Let them talk to their insurance agent. Then we get into contingencies. Let's talk about the difference between walkaway clauses versus a right to cure, and the reasonable man assessment versus the sole discretion assessment. So we talked actually under the seller's approval of the buyer's verification of funds. That one is actually specifically called out as a reasonable man contingency. It says the seller cannot withhold their approval unreasonably. That's the standard that's applied to any contingency, unless we specifically say it's a sole discretion contingency. So basically, if let's say my sale is subject to me viewing the property. I'm buying property and I haven't seen it yet, so it's subject to my review and approval of that property, my viewing and approval. We're going to want to make sure that that says that I can disapprove in my sole discretion. Because what another reasonable man might find acceptable or unacceptable about the property shouldn't affect my right to not proceed if I don't like the property once I see it. So that would be an example of a sole discretion contingency. And then we've got walkaway clauses versus right to cure. So the reason I like to talk about this at this point is because the very first contingency listed here is the title insurance contingency at line 143. This is not a walkaway clause. This is not an opportunity for the buyer to say, never mind, I don't want the property. They have 5 days from receipt of the preliminary title report and any accompanying documents such as CC&Rs, etc., to object to what they received, to say, I don't like the fact that the CC&Rs say no chickens. And then the seller has the right for a 5-day window to attempt to cure that objection. So if you say to me, I'm not comfortable with X that's on the prelim, and I say, oh, that's going to be satisfied at closing, the buyer cannot terminate and get their earnest money back. So that's a right to cure contingency, and that's what your title insurance contingency is. That preliminary title report review and CC&Rs review is strictly for the buyer to object to, and then if the seller cannot or will not cure it, then the buyer can terminate. The sale agreement no longer specifically calls out CC&Rs, it just calls out documents of record, which includes CC&Rs, so for those of you who fretted about that. And we just talked about the fact that this is not a walkaway clause. Now, the professional inspection contingency, on the other hand, is a walkaway clause. I have the right as the buyer to just say, I don't want this property, never mind, provided I actually have an inspection. I can't unconditionally disapprove of an inspection that I didn't get. There is a difference between the inspection contingency in the sale agreement and the professional inspection addendum. We don't typically use in our area the professional inspection addendum, at least not all that often. I don't see it. I prefer the language that is in the sale agreement because it allows the buyer to have as many inspections as they choose during the contingency period. So if I have a home inspector come through and he says, I think there might be an electrical problem in this home, I can have an electrician come out and I don't have to go back and ask permission. The professional inspection addendum is exactly the opposite. You have to, in advance, identify every inspection that you want to have, even though you might not have any idea that you're going to need it. So I always laugh and say, well, you can either just mark the home inspection box on the professional inspection addendum and then have to go back and ask for permission for anything else, or you can mark all the boxes and scare the pants off the seller. So I really, really prefer the language that's in the sale agreement that gives the buyer the opportunity to have as many inspections as they choose. Make sure you watch your time frames, guys, on the inspection contingency. This is the one that comes up to bite us the most often. Everything has to be completed during the inspection period, not just the inspection, not just the request for repairs, but the buyer and seller actually have to come to agreement within those 10 business days or whatever you changed it to when you filled in the blank at line 182. If you don't come to an agreement on repairs, then the buyer buys the property as is, and that's spelled out very clearly in the language. You're also not supposed to provide the inspection report or any portion of the inspection report to the seller unless the seller requests it, and then it must be provided. So this is one of those things that creates a whole lot of hubbub for very little reason. Don't refer to the inspection report in your inspection addendum or in your repair addendum because the seller doesn't have it to refer to. Just tell the seller what you want. And then later, if the seller asks for the repair or the inspection report, you must provide it as the buyer's agent. Even if the transaction is terminated, you must provide it. So let's not fight over the little things that just are nonsensical. Keep in mind, lenders don't like repairs, especially repairs that aren't done. So if you've got a significant repair that needs to be done on a piece of property, you might want to verbally negotiate through that before you start putting things in writing. And know that just saying I'm not going to send the repair addendum over to the lender could potentially be considered lender fraud, just depending on whether that particular lender expects to see it and would rely upon it if they had received it. So best to just negotiate through those things verbally, figure it out, and then do credits for closing costs. Remember that lenders don't like credits for repairs. So you can't say, seller to credit buyer $3,000 for new carpet at closing. The lender's not going to allow that. It will have to be a credit towards closing costs. And the professional inspection is the most common reason for a sale fail. So understand that getting an offer accepted is only the very beginning of the process. You resell the home over and over and over, and during the inspection is one of the times during which you resell that home. Prepare your clients. I always say the biggest part of our job is creating realistic expectations. Make sure your seller knows the buyer is very likely going to ask for some repairs. It's very unusual for there to be nothing that the buyer wants done on a home, no matter what kind of market we're in. And make sure that your buyer understands that they're going to get this 40-page inspection report and that it's probably not okay to ask for every little thing that the inspector called out for the seller to repair. So if they both just have that understanding, try to keep the seller's emotions and taking offense at, oh my, I think my home is perfect and I don't think I should have to make these repairs. Try to keep that eliminated by just preparing them for the fact that this is a third party, there's no emotion here, they're just calling out things that they think are important, and it's not personal. And then you decide whether you're willing to spend the money to correct these things or not. And then with Mr. Buyer, understand that if you ask for every little thing on the inspection repair report, it's likely you're not going to get the big things that you really do want repaired. So skip asking for the things that are unimportant, ask for the things that really matter. And then try to approach everything with good intentions, guys. Like I just said, prepare your clients in advance, but I can't believe how many realtors try to use the inspection contingency to accomplish other things. It makes me think of the government. You know, we need to provide aid because of coronavirus, but I have an agenda and I'm going to try to slip all of these other things into that aid package as well because I want to get these things accomplished, and here's an opportunity to do that. I see some agents do that with the inspections too, and the repair addendums. So this is not the time to renegotiate the contract. This is the time to negotiate repairs. Okay, so let's talk about lead-based paint for a moment. First of all, you should know that the lead-based paint rules are governed by HUD, so it's not something that ORF has any control over. It applies to homes that were built prior to 1978. If the home was built in 1978, lead-based paint law does not apply. So know that it's prior to 1978. The lead-based paint addendum is supposed to accompany the offer. In fact, the HUD rules say specifically that the offer is not binding until the addendum has been delivered. So the closer you can get that addendum to the time of acceptance of the offer, the less likely you are to get in trouble if HUD audits you. And you need to complete the addendum correctly. The fines are ridiculous, and HUD is back in the state of Oregon. They were just over in Eugene assessing fines. They will go through all of your files and look at your lead-based paint addendums, and if they are not completed correctly or timely, it is an $11,000 fine per incident. So, and that fine would be fined to you and potentially to the other agent as well. So you're talking about huge amounts of money, hundreds of thousands of dollars that companies are getting fined right now when HUD comes through and audits all of their lead-based paint disclosures. So don't let your managing broker down by not completing that form correctly. Let's talk about wells and septic systems. So there is a private well addendum, and the state of Oregon says that the seller of any property must have the water quality tested prior to transferring the deed to that property. So that's state law. So the well addendum, first paragraph or second paragraph actually says, Mr. Seller, you're going to comply with state law and you're going to have the well water quality tested. The difference between that and a septic addendum is that there is no law that requires septic systems to be tested. So the well must be tested. The septic system does not have to be tested, although I do understand that more and more lenders are asking for that. But you don't have to do it. I do think it's a good idea. I think that buyers should inspect everything that they are buying, but they don't have to. The other thing I'm noticing, folks, is that there is a pretty high rate of wells going dry in Central Oregon right now. So I highly recommend that your buyer have a flow test on the well, on the property that they are buying. It's just, nobody wants to buy and close on a piece of property only to have the well go dry. And so I recommend that you test that and make sure that the water that's being provided by the well is adequate for the buyer's needs. Then we get into the seller's representations. And that is going to be bottom half of page 5 of your sale agreement. So again, hopefully, as the seller's agent, you've had the seller review this prior to the time they receive an offer so they know what the representations are. But you as the seller's agent should know what this says. And there is a space for writing in exceptions to these items down at line 238. It's not a very big space, but you can write in if there are any exceptions. And I have buyer's agents ask me all the time if they should mark the boxes on lines 222 and 223 since these are seller representations. Yes, the offer needs to be complete at the time that it's sent over to the seller. If there's anything wrong, anything listed here that's not accurate, the seller needs to counter and correct it. But the offer needs to be complete when it comes from the buyer. So make sure you know what the seller's representations are. Then we get into the out-of-state seller's potential tax liability in section 15.1. A lot of agents don't realize this is even here. If your seller does not live in the state of Oregon, a portion of their proceeds could be held back to cover their Oregon state tax liability. So let's talk about FIRPTA. What is FIRPTA and why do we have it in our sale agreements? FIRPTA is the Foreign Investment and Real Property Tax Act, and most agents do not understand it. Most buyers and sellers do not understand it. And another one of my favorite sayings is, it's not a problem until it's a problem, right? Nothing's a problem until it's a problem. You could do everything wrong in your career, and if you never get caught, it's not a problem. FIRPTA is one of those things that when it's a problem, boy, is it ever a problem. And it doesn't happen hardly ever. But when it does, it is an immense problem. So what FIRPTA is it's an effort by the federal government to make sure that they get paid the taxes that are due by foreign owners of real property, of U.S. property. So if you are a foreign seller of property in the United States, a portion, a percentage of your gross sales price needs to be sent to the IRS at closing to be applied towards potential tax liability that you may have in the upcoming tax cycle. What the government did in their infinite wisdom, however, here I am with my mic again, what they did was they made it the buyer's problem if the seller doesn't pay their tax as due. So what they said was that if the seller doesn't pay the taxes and they are deemed to be foreign, then the buyer will be assessed the taxes and it will be a lien against the property, and the IRS can actually foreclose on the property and take it away from the buyer. There is only one document that protects the buyer from this happening, and that is having the seller sign what's called a certificate of non-foreign status. That document, if the seller certifies that they are not foreign, and it turns out they lied, the buyer is protected against the tax liability, but nothing else will do it. So it's absolutely imperative on every transaction that either part of the proceeds are, or not the proceeds, but part of the gross sales price is held and sent to the IRS if the seller is foreign or if they refuse to sign the certification of non-foreign status. So what our sale agreement says under the FRPTA language is that, Mr. Seller, you agree you will sign this certification of non-foreign status. If you refuse, then you will be treated as a foreign person, and a percentage of your gross sales price will be held back by escrow and sent to the government. So escrow handles this. There is no need for you to prepare, even though it is in the forms library, or actually I'm hoping that we maybe made that go away this year. Don't prepare a certification of non-foreign status. Escrow will take care of that. The challenge is that, in their infinite wisdom, again, the government put the seller's social security or tax ID number on their certificate of non-foreign status. So that means if the seller provides the buyer with this certificate, they're also giving the buyer their tax ID, which no seller wants to do, foreign or not. And of course, it's the non-foreign seller, so the majority of sellers who would be filling out this form, giving it to the buyer and giving them their social security number. So there is another form, just to create more confusion, there is another form called a qualified substitute form that allows for escrow to hold the certification form and provide the buyer with the qualified substitute form, which is basically an attestment that they have the other form. So your buyer at closing is going to get a qualified substitute form saying that the title company has collected the certificate of non-foreign status and they are holding it. So if the IRS comes knocking, they can provide that qualified substitute form to the IRS, and the IRS will then go to escrow to see the certification form, and then the whole problem goes away and the IRS goes after the seller. So as much as I hear buyer's agents say, well, this is a seller problem, no, it actually is a buyer's problem, even though the law was written to collect money from sellers. So understand that the percentages are huge, guys. It's a percentage of gross sales price, not proceeds. And depending on the sales price, for anything under $1 million, it's, or 300,000 to $1 million, it's 10% of the gross sales price. So, you know, our average sale price in Central Oregon is 480,000, somewhere in that neighborhood right now. So that's $48,000 that needs to go to the government. And then over $1 million, it's 15%. And then under 300,000, it's 0 with certain other qualifications, and there are certain foreigners that are exempt, etc. So we don't want to be the experts here. All our form says is you're either going to be considered foreign or you're going to sign this form to protect the buyer. So you just want to make sure that your escrow company is on it and is collecting the certification of non-foreign status and providing your buyer with the qualified substitute form. The next thing on this same page, right underneath FRPTA, is section 16, which is the as-is clause. So guys, everybody writing in that the property is sold as is, you don't need to do that. There's already an as-is clause in the sale agreement. Of course, it says as is, subject to the seller representations and the seller's disclosure and blah, blah, blah. So I always felt like this as-is clause is somewhat nonsensical, other than it does give you something to point to when you get that call from that buyer after closing that says, oh, I didn't realize, you know, that this or that, or the doors all squeak, or the dishwasher is really noisy, or whatever. You bought the house as is, Mr. Buyer, and it's something for you to be able to point to if you get into a disagreement with your client, with the other agent. The property is being sold as is, subject to the representations made by the seller. Homeowners Association Townhome Plan Community Addendum. It has a new name now. It starts with Homeowners Association. However, we didn't change it in the form, and it's in the sale agreement, so it's still referred to as the Townhome Plan Community Addendum in the sale agreement, but it is now the Homeowners Association. This should be used anytime there is an HOA. It is not necessary for any other reason. It is specifically about HOAs. But here's the deal, guys. This is not state law. This is something that we created to protect buyers from finding out after they've bought a home that their HOA is now going to assess all owners a bunch of money because they don't have an adequate amount of reserves, or that there was a lawsuit pending against the HOA at the time they bought the home, etc. So this is a contingency to benefit the buyer by gathering documents from the HOA to certify the status of the HOA for the buyer to approve or disapprove. If you don't include the HOA form with your offer, the seller has no obligation to provide it to you, and there is no contingency for getting those documents. And I've heard it from the agents I work with more often than I'd like to admit recently, where they're saying to me, oh, yeah, I didn't attach that, I didn't fill that out, I just asked the listing agent to prepare it and send it back to me. That doesn't work, or you haven't protected your client. You haven't created a contingency that gives them the option of terminating the transaction if they find out that the HOA is not fiscally sound, or that there's a lawsuit, or that there's something else going on. So as a buyer's agent, you should be including this form when you write your offer and sending it over at the time you write the offer. Section 18, line 280 asks if there's an alarm system. I really wish we didn't have an unknown box on here. Guys, there's no such thing as unknown. If you have the buyer and you don't know if there's an alarm system on the house, call the seller's agent. Call the listing agent. I don't know why we're so hesitant to talk to each other these days. Call them and ask them if there is an alarm system. If they don't know, they can ask the seller. Somebody knows. There is a source. Somebody knows whether there is an alarm system or not. So let's get to the bottom of the matter and check the correct box. Let's talk about the smoke and carbon monoxide detectors. This part was rewritten this year in the sale agreement. They have to be installed and meet code within 15 business days of acceptance. And the purpose of making it that many days, and there is a blank, you can adjust that, but the purpose behind the default of 15 days, the thought process I should say, is that by then you've had the home inspection, and the home inspector will have called out whether or not there are missing smoke alarms, expired batteries, no carbon monoxide detectors, whatever. So you can get those installed before the appraiser comes out. Because if they're missing when the appraiser comes out, the appraiser has to come back, and that's an additional charge to the buyer. So this is a way of saying, Mr. Seller, as soon as we call it out from the home inspection, you're going to get these installed so that the appraiser doesn't have to come back. On the wood stove addendum, I'm going to give you the opposite advice of what I've just told you about the HOA addendum. If you don't know if the wood stove is certified or not, don't include the addendum with your offer. Wait and attach it after you know for sure that the wood stove is not certified. Because the form doesn't accomplish anything if you mark unknown on it. There is the option to mark unknown. There's even the option to mark that it is certified. But the form's unnecessary in both of those instances, because until it is definitely not certified, there's no expectation that the seller is going to do anything. As soon as we know it's not certified, then the seller has to agree to remove the wood stove prior to closing, destroy it, and send evidence to the state that they've done so, or the buyer can assume that responsibility. But just wait on that addendum until you have confirmation on the certification. And then there's the home warranty box here, section 22, line 290. Seller's agents, make sure you read this because there is a cost. If your seller signs it and you don't point out that they have agreed to buy a home warranty, you might be buying it. Home warranties are great insurance policies against future issues. Now you won't be getting that call that says it's been a week since closing and the dishwasher stopped working, and of course the buyer always assumes the seller knew and hid it or jury-rigged it somehow to make it work. So it will save you a lot of heartache. And the beauty of the home protection plans is that the seller gets covered during the listing period. So, and they don't pay for it till closing. So the seller can actually agree to buy a home warranty. It covers the buyer for a year after closing, and it covers the seller for up to a year of the listing period. So it's a really good investment. If you've never looked into home warranties, I highly encourage you to do so. Now let's take a look at escrow and closing. So the first thing you'll notice is that in section 24, it says that the agents and firms will be paid in accordance with the listing agreement or other agreed upon compensation form. So it no longer is in the sale agreement. Now, most of you probably that are listening to this don't remember when it was in the sale agreement, but it was. Up until the late 90s, the actual commission amount payable at closing was a big blank in the sale agreement, and we had to throw it out there for everybody to see that the seller was going to pay $24,000 in commissions at closing. So now it just references the other document. Remember, the MLS is strictly an offer of cooperation and compensation. So expired, terminated, and withdrawn listings don't have an offer of compensation. So if you are the buyer's agent, you don't have a listing agreement, right? You have no protection for the commission other than the MLS. And the MLS says that the seller's agent has to pay you whatever they offered in the MLS. However, if that listing is expired or terminated or withdrawn or was never in the MLS, you'll need to make sure you've gotten something in writing from the seller's agent agreeing to compensate you. Otherwise, you have no argument that entitles you to compensation. So I always worry about that a little bit because especially in this market right now where there's so little inventory, we're showing our buyers, we're calling listing agents and asking if we can show expired listings or listings that have been terminated because there's nothing else to show. And then we forget that you just write this offer and get it accepted, and you better hope that the seller's agent somehow got an agreement for compensation with their seller and that they will pay you because you have nothing to point to if they refuse to. So just be cautious, protect yourself. And back to the earnest money conversation again, only this isn't about the amount. This is about how to fill out this section 26, where you enter the amount of the earnest money that should match the amount on page 1. Select the number of days after acceptance for the deposit. It defaults to 3. And then be sure to check the correct box for where that money is going to go. So the most common box is the first box on line 313 because most companies these days don't have client trust accounts because we don't want the liability for the client trust account. But if your company does have a client trust account, then you could mark line 314 or mark line 315. Most of the time it's going to be line 315. Apparently over in the Valley, many companies hold the earnest money until closing and then transfer it into their regular checking account to pay their commission. That makes me nervous. That feels like commingling to me. It's perfectly legal. Escrow reduces the amount of your commission by the earnest money, and you just transfer the earnest money from your client trust account into your operating account. But boy, that would make me a nervous wreck. So in Central Oregon, we really don't do that, but because this form is statewide, we have the option on there on line 314. But if you have a client trust account here, know that it's much more likely that your Central Oregon office is going to transfer that money to escrow prior to closing. Also know that failure to deposit earnest money is a breach of contract and causes the transaction to terminate. So if you're going to let that default of 3 business days be when the earnest money is due, make sure your client can get that money into escrow within that 3 business days. And then let's talk about escrow and earnest money disbursement. So let's take a look at section 27.1. It requires escrow to hold funds until they receive either a written agreement signed by both the buyer and the seller for the disbursement of the funds, such as a termination agreement, or a ruling by a court or arbitrator. So 27.1 is the peace of mind clause, is what I think of it as. It's the paragraph you can point to for both your buyer or your seller to say, don't worry, that money's not going anywhere until we've agreed on where it's going or until the courts tell us where it has to go. So don't worry, Mr. Seller, the buyer's not going to get their money back. And Mr. Buyer, the seller's not going to get your earnest money until a court or arbitrator directs it or until you agree. Now, Section 27.2 outlines the terms under which the earnest money will be refunded to the buyer, which is basically if they don't close because of a contingency contained within the sale agreement. 27.3 outlines the terms for earnest money forfeiture to the seller, which includes the buyer's failure to redeem or deposit earnest money on time, or if their check bounces. So read those sections, guys. It's important you understand under what circumstances the buyer is entitled to their earnest money or the seller is entitled to the earnest money. So understand that sections 27.2 and 27.3 outline the arguments. This is what you're going to go into arbitration or small claims court arguing, that it says right here that I should get my money back. But section 27.1 doesn't allow for escrow to interpret who should get the money. They must hold it until the parties agree or somebody prevails in a court or arbitration. So it's a good thing, but it also, I've seen buyers and sellers get very upset when they say, well, you said, Mr. Agent, that if the buyer didn't close on time that I would be entitled to the earnest money. Why can't I just have it? Or the buyer says, I unconditionally disapproved of the home inspection. That's a contingency. I should get my money back. And the seller's not signing off. Why can't escrow just release it? They can't. They're a neutral third party, and that's in section 27.1. So you can point to that. Again, there's so much in the sale agreement that is there just strictly for the purpose of you being able to point to it and use it to help explain what's going on. Section 28.1, this is your closing date. Once this date has come and gone, your transaction is dead. So don't let. So that's it, basically. In summary, write good contracts, guys. Protect yourself and your clients. Communicate. Communicate. Let me say it again. Communicate. Talk to each other. What is the hesitancy for agents to just pick up the phone and call each other? Ask about the deadline for that offer. Ask about the alarm system. Ask the questions that you need to know to write an offer and communicate effectively. Address potential issues immediately. Don't let things fester and get out of control. Even if it's a little as something, start talking about it. Resolve the little things before they become big things. Take responsibility for your mistakes. It's okay to make mistakes. Own up to it, apologize, accept it, fix it. Work toward a resolution before the formal process is necessary. Right? We don't want to go to small claims court, mediation, or arbitration. I know a lot of agents who throw their hands up and go, well, we'll just fight it out in small claims. You don't want a third party interpreting the outcome of your contract. You and your clients and the other realtor and their clients intimately know what the intent of all the parties were and know what the agreement was. You are best suited to resolve the dispute, not some third party who comes in with no skin in the game making the decision. I hope you feel like you're equipped now to write a great contract. My final thoughts before you go, just because you compromised doesn't mean you weren't right. It's okay to compromise. If you can buy your way out of a problem, you no longer have a problem. Remember that. Just fix it. Whatever went wrong, fix it and move on. You will be working with that other broker again in the future. Try not to burn bridges, guys. Be nice to each other. Do unto others what you would have done to you, right? The golden rule. And keep smiling and be nice. It's not that hard.